5 seconds to go. Start. Aggrieved by the aforesaid communication of the SEBI, the appellant challenged the same before the High Court of Bombay in writ petition number 300 of 2019. The High Court, wide order dated 4th February 2019, dismissed the aforesaid petition. It may not be out of context to note that SEBI also rejected the supplementary application filed by the appellant herein. On 16th July 2020, SEBI filed a complaint in the court of SEBI Special Judge Mumbai, praying therein as under that this honorable court may be pleased to issue the process against the accused for the continuing offences punishable under section 24(1) read with section 27 of the SEBI Act 1992 as amended in 2002 for having violated regulations 3, 5 and 6 of the SEBI Regulations 1995, Regulation 11 of the SEBI Regulations 1997, and be further pleased to deal with the accused in accordance with the law. That this honorable court may be pleased to issue the process against the accused for offences punishable under sections 77(2) and 77A read with section 55A of the Companies Act 1956. On 30th September 2020, the SEBI Special Court dismissed the complaint filed by SEBI as being barred by limitation. The aforesaid order has been challenged by SEBI in Criminal Revision Application number 209 of 2020 before the High Court of Bombay. In the aforesaid proceedings, the appellant filed an application being IA number 1945 of 2021 seeking the following documents. The High Court, after extensively hearing the arguments on the aforesaid application, passed the impugned order on 28th March 2022 in the following manner. At this stage, the prayer sought for in the interim application cannot be considered without hearing the main revision application. It is pertinent to note that the respondent number 1 SEBI, that is original applicant in the revision application, has filed the aforesaid revision application seeking, quashing and setting aside of the impugned order dated 30th September 2020 passed by the learned SEBI Special Judge, City Civil and Sessions Court, Greater Bombay in SEBI Miscellaneous Application number 686 of 2020, by which the learned judge dismissed the miscellaneous application number 686 of 2020 only on the ground that it was barred by limitation. Therefore, the question that arises in the revision application is whether the complaint filed by SEBI was barred by limitation or not. In view of what is stated herein above, the interim application will have to be heard along with the main revision application on the next date. It is made clear that all contentions of the parties in the aforesaid interim application are kept open, including the question of maintainability. Aggrieved by the aforesaid order, the appellant RIL has filed the present appeal. Mr. Harish Salve, learned senior counsel appearing on behalf of the appellant, contends that the challenge to the maintainability of the present appeal is misconceived. He stated that the interim application filed for seeking documents was argued at length before the High Court, which was ultimately not considered. Stop.